Did you know that 67% of Americans have no estate plan in place? Imagine that's approximately 90 million homeowners at risk. Are you worried about the security of your assets? Want to ensure a smooth transfer of wealth to your loved ones? Look no further. Our comprehensive video on living trusts reveals everything you need to know. United Estate Planning and Protection is on a mission to bring awareness to safeguard your assets through our all-inclusive 360 package, tailored to fit your needs. Having assets under your name comes with certain risks, which can be avoided by establishing a living trust. In the next few minutes, you will learn how living trusts can shield your estate from probate, minimize taxes, and provide privacy for your beneficiaries. Here you will unravel the secrets to preserving your hard-earned wealth. Some of you may say you have a will, corporation, or joint tenancy. A will is simply a document that states where your property and assets are to go, which become public knowledge after your passing. Your family is required to go through probate to recover your estate, which may not align to your wishes. Now, if you have a corporation where all the shares are under your name and you pass away, probate is still inevitable. If you have a joint tenancy, and the last surviving tenant passes, probate will also take place. Did you know that in the probate process, a judge will sign on your behalf and distribute your assets according to the law during the next 6 months to 3 years, if not more, without any guarantee that your loved ones will receive anything? With a revocable living trust, it takes effect immediately according to your wishes, and it avoids probate altogether. Let me give you an example. Let's just say your dad lives in California, and he owns a home worth $800,000, and he wants to leave it to you upon his death. Let's assume he only has a will and he passes away. In order for you to have the opportunity to obtain his estate, you have to take the will down to court, known as probate court. A judge then has to validate the will to make sure dad wanted the home to be left to you. The process can take anywhere from 6 months to 3 years or even more, until you can legally gain title to the property, which then again is never a guarantee. Meanwhile, the probate procedure will have a court cost of about $19,000 statutory fees, plus special fees in the state of California taken out of your inheritance. Meanwhile, you will be responsible to pay all the taxes, insurance, mortgage payments, while waiting out the process to prevent foreclosure. If dad had taken prior action, he simply would have done what? He would have set up a revocable living trust, used as a private tool, to designate where his assets are to go upon his passing. Dad would have taken the time to transfer the deed from his name, John Doe, into the title of the trust, John Doe trustee for the John Doe Living Trust, held for his benefit while he was alive. He could sell it, refinance, gift it, and still have full control over his assets, without affecting his property taxes at all. And held for you after he has passed. Let's say, worst case scenario, dad passes away 1 year later. The house is now yours, and it costs absolutely nothing, no time or money spent. No one is promised tomorrow. Stop procrastinating. Now is the time to take responsibility to have your financial affairs in order. Most people work hard to provide the best future for their children and generations to come. Now is your opportunity to decide who will care for your minor children and unborn children in the event of your disability or death through a guardianship option. You have the power to protect your child's inheritance from his or her spouse in the event of divorce, financial hardship, or death. Even if you currently do not have children, future children can also be named as beneficiaries of your living trust. At the end of the day, your wealth should be distributed to those you have intended. By taking action today, you decide who will benefit from your legacy. Whether it be your children, your dear friend, a charity, your beloved pet, you name it. We offer the following all-inclusive services in order to help you secure your estate and assets through your complete 360 package. 1. A revocable living trust. Gives you complete control and protection over your assets while you're still alive. Once all grantors pass away, it will become irrevocable, where no one can change your wishes and percentages of distribution to your loved ones. 2. A irrevocable living trust. Cannot be changed or cancelled. This is often done for tax planning or to protect assets from creditors. 3. A special needs trust. Allows for a disabled person to maintain his or her eligibility for public assistance benefits, despite having assets that would otherwise make the person ineligible for those benefits. 4. A trust certificate. Is a legal document used to certify the existence of a trust, and oftentimes required before the trustee can take action. 5. A durable financial power of attorney. Is a document that authorizes your agent, a person you choose, to manage your financial affairs, if you become unable to manage them yourself. 6. A health directive power of attorney. Allows an individual to choose an agent to make medical decisions on their behalf, and select end-of-life treatment options. 7. HIPAA authorization and waiver. Gives the healthcare providers for the dependent adult authorization to release otherwise confidential medical information to their agent. 8. A pour-over will. Is a legal document that ensures an individual's remaining assets will automatically transfer to a previously established trust upon their death. 9. A guardianship. Is a court process by which a person other than a parent is given custody of child or authority over a child's property. 10. A pet trust. Is a legally binding document that ensures that funds are available and a caretaking system is in place for your beloved pet. 11. A gun trust. Is created to ensure the smooth transfer of your firearms when you pass away. The trust is a legal entity that officially owns the guns, and its beneficiaries will be legally permitted to continue using the firearms after the owner's death. 12. An IRA trust. A legal arrangement that allows you to designate a trust as the beneficiary of your individual retirement account. This type of trust is specifically designed to provide greater control and protection over the distribution and management of your IRA assets after your passing. All of these 12 features are included in your 360 package as needed to ensure you are fully protected. In addition, we have customizable options available for you if applicable to your unique situation. Start your estate planning journey to secure your future and protect your assets. There are several reasons why you may not have a living trust in place. Either you're not aware of the consequences of being unprotected, or you perceive that establishing a living trust is too costly, complicated, and time-consuming. Or maybe you've been procrastinating and taking life and health for granted and postponing for later, leaving your assets unprotected and exposed to a court to decide on your behalf. If you have assets over $185,000, a living trust is an essential document that you need to set up while you are living. Whether you have a mortgage balance or your house is paid in full, or you have a primary residence or rental property under your name, a living trust gives you the opportunity to provide a higher level of privacy for you and your loved ones. Prevent your loved ones from being forced to sell the home at a deep discount due to probate costs. Exclude children from a first or outside marriage that are not entitled to benefiting from your hard-earned assets through a disinheritance clause. If desired, qualify for benefits such as Medi-Cal. Exempt assets from medical recovery in order to prevent medical bills from going after your assets. Exempt or minimize estate tax, gift tax, and income tax ramifications. Provide the peace of mind you deserve, and much more. The process works like this. The grantor, a single individual or grantors such as husband and wife, grants the property and assets to a revocable living trust. Now the trustee, either one or multiple, is in charge of making all decisions under the revocable living trust. Typically, grantors are also the trustees. As the trustee, you will always be able to change beneficiaries, refinance, sell, or anything you wish to do with your assets, meaning you're always in control while you're alive. For example, if you are married and your spouse becomes disabled, the disability clause in the living trust will give you full authority to continue to manage your assets, Or if you are married and your spouse passes away, the trust will continue to be revocable and you, as the surviving spouse, can do any changes as desired and continue in full control without going to court. Once the last trustee has passed away, the revocable living trust will become irrevocable, meaning no one can change beneficiaries, percentages, and distribution of assets that you have drafted today, according to your legacy distribution and last wishes. In addition, your loved ones will prevent any wait time, court intervention, and heavy legal and court fees. Now this is peace of mind. Today you have the opportunity to have a well-established foundation and protection on what would have cost thousands and thousands of dollars. We understand people's lives are constantly changing, and how expensive it can be to schedule a consultation with an attorney that costs on average $500 an hour just to change or amend your documents. With our services, you're going to have a complimentary meeting to go over your estate plan with our seamless, tried and true process. At a minimal cost, you will have access to make amendments to your living trust, because we understand people's lives do change. Although we are not able to provide legal advice, we have partnered with Just Answer It in order to have access to thousands of attorneys at no cost to our clients. Additionally, we have payment options available with our instant application approval. No hard credit check required. Here at United 360, we have made it so simple, efficient, and cost-effective to take action and protect your assets and loved ones today. Now, whether you take the next steps with us or someone else, it is imperative that action is taken immediately. Begin by filling out a brief questionnaire or speak to our experts today at 833-1945. 24 hours, 7 days a week. Thank you for your time and opportunity to assist you in protecting your legacy. Disclosure: we work under your direction, and we do not provide legal advice. We are not a law firm, state or government agency. We are not a one-size-fits-all program. It is your responsibility to notarize and record your living trust to make it valid. United 360 is a registered, bonded, and insured legal document assistant through the state of California, facilitating legal document preparation based on the direction of our clients. To get started today or for any additional questions, contact us at 833-1945. 24/7. We look forward to connecting with you.